This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law's Intellectual Property Review. I'm Josh Block. The $6 Million Man begins with memorable dialogue between a pilot and Flightcom. Before his plane crashes, Steve Austin says, "Flightcom, I can't hold it. She's breaking up. Today, the $6 Million Man pilot TV movie and Season 1 was released on DVD. But if you'd like to see that opening scene or significant portions of the series, you can just go to YouTube. New legislation that has been proposed in Congress may change that. According to the International Federation of the Phonographic Industry, 40 billion music files were shared illegally in 2008. That amounts to 95% of all music downloads. Online piracy, or perhaps better stated, copyright infringement on the internet, is an issue. But what role does a search engine, internet service provider, or even a social networking site play, and what liability should they have when a copyright is infringed on the internet? I'm joined now by Bloomberg Law's Intellectual Property Product Manager, Michael Dunn. Before we get into the particulars of the new legislation, copyright infringement on the internet is a well-established problem. So it seems a little bit like this legislation came out of nowhere. Can you tell us the background here?
We already have in place, as most people are aware, the Digital Millennium Copyright Act, which is the main piece of the Copyright Act that sort of governs liability for online infringement. And a lot of provisions of the DMCA represented a compromise between the tech industry and the entertainment industry and the content owners, and a lot of people are unhappy with that compromise. In addition to that, there's the whole issue of the inability of U.S. copyright owners to reach foreign websites and sort of take foreign website owners and foreign web hosts to court to get infringing content removed. And that's always been an issue. So those things have been bubbling below the surface for a while now, and now they've sort of come to a head, and we've seen both in the Senate and the House new bills that are proposing to handle this problem of online piracy.
Practically speaking now, a user of YouTube puts up a clip of, say, Jon Stewart on The Daily Show. Copyright holder contacts YouTube, and then YouTube pulls it down. Is that how it works now?
That's basically how it works now, and it has to be, under most courts that have decided this issue, it has to be a specific notice for a specific file. So, Viacom has tried to argue in court that YouTube has knowledge that there's lots of infringement on its system, so it should be forced to proactively monitor for infringement and take files down on its own. And YouTube has responded that the DMCA provisions seem to make clear that it has to be a specific notice of specific infringing content, and they don't have to, unless there's this concept of red flags, YouTube doesn't have to proactively monitor its system for copyright infringement. Entertainment companies and content owners haven't been happy with that system.
Even opponents of the proposed legislation must recognize that there is rampant copyright infringement going on the internet. Do they agree at all that more should be done?
Most opponents to the bill are not opposed to the idea that preventing copyright infringement online or preventing piracy online is a worthwhile goal or something that needs to be done. I think the main objections to this bill and the Stop Online Piracy Act in particular, which is the House version of the bill, are that it goes much too far. It goes much too far in both the way that it defines what an infringing website is and the ways that it allows both the government and content owners to police infringement online.
I do want to go into the specifics of the bill, but in the past, the policy argument has favored internet development and growth. Of course, with Facebook valued at more than $100 billion as they consider an IPO, it's harder to make that argument. But some would argue that this policy of internet growth has come at the expense of copyright holders. Does this proposed legislation represent a shift in that policy?
It's not clear that it represents a shift in the policy, but I think to content owners, what it represents is, you're right in that the policy up to this point has been to allow unimpeded growth of the internet, and the argument that these content owners would certainly make is that growth has come at their expense. The content industries are responsible for millions of jobs in this country, and they feel like every act of piracy is essentially costing the economy jobs and costing them profits, and they feel like something has to be done, and if that puts more liability and more onus onto technology companies to actually do something to combat online piracy, then I think they feel like that's a fair trade.
Let's talk specifically about the bill in the House. That is the Stop Online Piracy Act. Section 102 of that allows the Attorney General to bring an action against a foreign website. Can you explain how that would work?
That's the main provision of the bill. That was the original intent behind the bill, and that's what most defenders of the bill will point to as its primary purpose, which is it basically allows the U.S. Attorney General's office to identify rogue websites that basically exist to allow people to commit online copyright infringement or to sell counterfeit products online committing trademark infringement. And specifically, it targets foreign websites. So these are websites that are either hosted on a foreign web host or that are owned by a foreign company that are basically beyond the reach of traditional U.S. copyright and trademark law through the U.S. court system. And what this provision of the bill, if it's enacted, would allow the U.S. Attorney General's office to do would be to go to court and present its claim that these are sites dedicated to infringement. They'd get a court order saying such, and then they'd be able to serve that court order on an internet service provider or a search engine or a payment processor like Visa, MasterCard, PayPal, or an internet advertising network like Google's advertising network, basically prohibiting those companies from continuing to do business with this foreign website. And in the case of an internet service provider, it would require the ISP to basically block access to this infringing website. So a user would try to type in the web address for the website, and instead of getting served up the actual website, they would get nothing. They get an error message, or they might get a message that says, this website is blocked due to copyright infringement. And the same thing with a search engine. A search engine would be prohibited from returning this infringing website as one of the search results that was responsive to a user's inquiry. The idea being targeting specifically, Pirate Bay type websites or websites that are foreign websites through which people acquire full-length movies or full-length CDs, or through which people purchase counterfeit, handbags or counterfeit watches. To shut these e-commerce foreign websites that are targeted towards infringement down altogether, because the entertainment industry and the content owners see each one of these sales or each one of these downloads as a loss in their profits. Whether or not it actually would be is a debate, but they see it that way. They see that every time someone buys a counterfeit bag or every time someone downloads a movie without paying for it, they're losing profits.
Now, one fear that critics have put forward is, and I think this is in particular to Section 102, is that there are unintended consequences. And so if you block a website, a foreign website, that there could be a rise in hacking, that someone will find a way to get to that website anyway.
That is one of the concerns. The concerns against this are there's a number of them. There's the security concern. There's a lot of concern among security experts that forcing ISPs and forcing search engines to block these websites at the DNS level, the domain name system level, would create a lot of security concerns for the entire domain name system altogether. Additionally, there's a concern that it would block a lot more websites than intended. The idea being, if you block a top-level domain or if you block a main website, there might be a bunch of subpages that are associated with that page that actually aren't connected, especially if we're dealing with like a web hosting company that might get inadvertently blocked. And we've actually seen this happen when, like for example, the Department of Homeland Security has tried to block access to certain websites that are hosting child pornography in the past. And in one instance, they ended up blocking, I think it was 90,000 websites because they were targeting one, and the order was just too broad, and it blocked 90,000 websites, most of which are completely legitimate. And it didn't just block them in that instance. It actually put a message on the page saying, this website is blocked due to hosting child pornography. So you can imagine the kind of effect something like that would have on a legitimate business.
In an op-ed piece in the New York Times, Rebecca McKinnon argued that the bill amounts to a nationwide system of web censorship, and the practical effect could be that our internet system could be similar to China's. Do you have a sense from the proposed legislation if she has that right?
People say this type of behavior is not something that a country like the United States should be engaging in. Critics have equated it to something like China's, internet firewall that blocks all political dissent. Essentially, what it would be doing is allowing, or at least according to critics, it would be allowing the U.S. Attorney General's office to create a blacklist of prohibited websites. And ultimately, while there is some court supervision, it's not clear exactly who's determining that those websites are infringing websites and who's going to speak up to defend those websites. I mean, you got to imagine, if it's a big business, obviously the owner of the website, the foreign website, would speak up and challenge this in court. But if it's someone's personal website that's getting blocked in the United States, it's not clear what else is on that website, what sort of First Amendment activity is being blocked, what sort of legitimate commerce is being blocked. What if the infringing activity that's taking place on that website is a really small percentage of what's actually happening on that website? Then you could be losing a whole bunch of protected speech in an effort to block these infringements. The critics would argue that that's not the way that we do business in this country. That is equivalent to web censorship ultimately. Now, obviously, proponents of the bill would say we do that in some respects already, right? If it's a U.S. hosted website, you go to court and you get a court order, and you can even seize the domain name. So a lot of this sort of blocking for infringement already happens, and it happens with respect to child pornography and some other issues. So perhaps the concerns are overstated, but there is a legitimate fear of the message that this is going to send to other countries, basically saying, well, the U.S. government engages in web censorship with respect to foreign websites, so why in the world should it be lecturing a country like China on what its responsibilities are?
Section 103 targets the funding of sites involved in infringement. How does that section work?
Section 103 is actually, I think, the more interesting and the more controversial part of this bill, in that whereas Section 102 is aimed at giving the U.S. government, the Attorney General, a way to combat foreign websites that infringe, Section 103 is more of a private remedy. It basically gives a U.S. copyright owner, a private entity, the ability to cut off business to infringing websites. And in the case of Section 103, there's no requirement that they actually be a foreign website. So the way the provision as drafted would work is it would allow a copyright owner, let's take Viacom as a prototypical example, to identify websites out there that are infringing its copyrights or that are infringing its trademarks. And I think the way the bill defines it is the websites dedicated to the infringement of U.S. intellectual property. And once it's identified these websites, it's allowed to file a notice, similar to a notice and takedown under the DMCA, but a little different. They're allowed to file a notice with credit card companies or credit card processing companies, so whether you're talking about PayPal or Visa or MasterCard, and internet advertising companies, and basically requesting that those companies stop doing business with this infringing website. Now, the bill's a little fuzzy on what happens if these payment processors and internet advertisers refuse to comply. But the way the bill is drafted, the assumption is that they will comply. So Viacom, in this case, would file a notice with PayPal saying, stop accepting payments from this particular website because it's dedicated to the infringement of intellectual property, and PayPal would voluntarily cease doing business with this website, basically cutting off all the funding to the website. And the bill does allow for a counter notice, basically allowing the website to send a notice to PayPal saying, I'm not dedicated to the infringement of U.S. intellectual property. But notably, unlike the DMCA, there's nothing in this bill that would require PayPal to reinstate its business with the website.
So the copyright holder could go after any one of these parties that doesn't comply, whether it's PayPal in this instance or the hosting site.
Well, that's the interesting ambiguity in the bill, in that the bill specifically says that it doesn't affect traditional definitions of contributory copyright infringement and vicarious copyright infringement. So if Viacom or whatever the company may be wanted to go after the payment processor or wanted to go after the internet advertising network, they would have to do so under traditional theories of copyright infringement. And it's not clear that they would be able to reach those companies. They might, or they might not. It's not really a well-defined area of law. But certainly one would think if they sent a notice to PayPal saying this site is dedicated to infringement and PayPal refused to do anything, they would have a much stronger contributory copyright infringement if they wanted to make such a claim against PayPal.
So there is an immunity provision as well. What does it take to qualify for immunity?
What the immunity provision does is it basically immunizes PayPal or other payment processors and credit card advertising networks from any liability for complying with the notice, right? So if I send a notice to one of these payment processors saying stop doing business with this particular website, and they stop doing business with the website, but the website is actually not infringing, it was a fraudulent notice on my part, it basically immunizes the payment processor or the advertising network from any liability for complying with the bill.
The various parties who would be affected, the internet service providers, the search engines, the social networking sites, are they equipped to handle what the legislation would require? Would they be able to write code to catch infringing content? Would they have to hire teams of people to look at everything posted on their sites and clear it? How would this work?
It's a very good question, and I don't know that there's a clear answer. One of the most controversial parts of Section 103, in addition to what we already discussed, is the way it defines a site dedicated to the infringement of intellectual property. And there's the traditional definition, what you would think from reading the words, but then there's also a sort of willful blindness definition, which says that any site that deliberately takes actions to keep it from informing itself of whether there's infringement going on its website, that site can also be considered dedicated to the infringement of U.S. intellectual property. And that's the one piece that has a lot of social networking and a lot of user-generated content websites concerned, because as we discussed earlier, under current law, under the DMCA, there has to be a specific notice of a specific file that's infringing. Under this sort of willful blindness definition, it would seem to suggest that there's almost a proactive responsibility on the part of sites like YouTube or Facebook or Twitter or any other site that hosts content to monitor the content that's on the site to make sure that it's not infringing. And, how exactly would that work? There are mechanisms in place for these sites to monitor what gets posted. For example, YouTube monitors for pornography and various other things that violates its terms of service. But YouTube's argument has always been it's a lot harder to monitor for copyright infringement because it has no way of knowing, number one, who the copyright owner is, and number two, it has no way of knowing whether the file was posted with the authorization of the copyright owner or not. Additionally, it has no way of knowing whether it's a fair use of that copyrighted material without actually going through an actual analysis. So there's a lot of questions here about how far this bill would go and how technology companies could even comply with it if they wanted to comply with it. And I think that's a lot of the reason that we've seen in the last few weeks alone such a strong negative reaction to this bill from the tech community.
Some opponents argue that it would be so burdensome that it could put some internet companies out of business, that it could be a barrier to entry for a new startup.
Well, you could foresee a scenario where a company like YouTube is not going anywhere, right? I mean, YouTube will do whatever it needs to do to comply with the law, or it will defend itself in court if it doesn't comply with the law. But if you take YouTube when it first launched, when it was a startup business, when it wasn't owned by Google, and you would have to imagine the staggering liability that they could be facing for their business model. And the same analysis goes for your Facebook and your Twitter as compared to some new startup social networking industry or business. The argument at least is that those new companies are going to face crippling liability potentially, and it's going to scare a lot of them out of the space altogether. And the ones that do go into the space will quickly exit it if they're sued.
A company like YouTube will exist, but could this drastically change YouTube?
One would imagine it could. I mean, if this bill passes and it was interpreted to mean that YouTube has to basically proactively scan its entire network to make sure that all the files that it's posting aren't infringing anyone's copyright, or it could basically be forced to stop doing business with any sort of advertising network or any sort of payment processor, you could imagine a scenario where YouTube either takes a lot longer to post files because it has to manually scan every single one of them, or the amount of files that are available on YouTube is significantly decreased. And, one would think that we would lose a lot of protected content, a lot of fair use, a lot of, files that actually weren't infringing, but some overzealous lawyer at a content owner thought that they were, or wanted to, scare off anyone who might be infringing. So we could potentially see a lot of changes in the way the business is done, but proponents of the bill would argue that that's not what this bill is intended to do. They would argue that Section 103 is more narrowly drafted than that, and it's only really trying to target sites that are really actually dedicated to infringement. The question, obviously, is how to define that.
In my introduction, I used the example of the $6 Million Man. If I go to YouTube right now, I type in $6 Million Man, you can imagine the amount of hits that I get and the kinds of things that I can watch with $6 Million Man. I'm imagining that most of that is not posted with the consent of the copyright holder. My results are going to drastically change.
Well, and the content owner's argument would be that they should, right? The argument would be if those things are actually posted and they are infringing, and they're not posted, and they're not fair uses, and they're not posted with authorization, then you shouldn't be able to access them through YouTube. And the fact that you can access them through YouTube means that whoever is the content owner in that case actually hasn't done all the work that's necessary to send takedown notices to YouTube. Whereas if you have a more proactive and copyright owner, like the owners of The Daily Show and the Colbert Report are very, very proactive in this respect, then you wouldn't find those results to begin with. So there's an argument on both sides. The proponents of the bill will argue that, look, this is infringing content, so if your user experience changes because you're not able to access infringing content, that's good. Critics of the bill will argue that you're going to be losing a lot of protected speech in the interim. You're going to lose things that are authorized. You're going to lose things where there's dispute over ownership. You're going to lose things that are fair use. A lot of this comes up in political advertising, for example, where political ads will use a particular song or use a snippet from a news event or a debate or something like that, and the copyright owner will claim that that's an infringement, but it might not actually be an infringement. It might actually be a fair use of that copyrighted content. So a lot of those questions, if they're forced to be decided at the level of YouTube making the decision, are going to, I think there's going to be a lot of erring on the side of removing to avoid liability.
In the House, this was introduced by a Republican. Is this a politically partisan issue?
I don't think it is. And IP in general is one of the places where a lot of the traditional left-right breakdown doesn't happen. A lot of the breakdown is more along the lines of congressmen and women who represent content industries or districts that have a lot of content industries in them versus congressmen and women that represent the tech industry and areas of the country where there's a lot of tech industries. We've seen the bill was a similar bill called the Protect IP bill was introduced in the Senate by a Democrat. This bill was introduced by a Republican in the House. There's a lot of co-sponsors that are Democrats. On the other hand, Nancy Pelosi has come out against the Stop Online Piracy bill, saying the definitions are too loose and the bill goes way too far. And she's been joined in that opposition by people like Rep. Darrell Issa, who is definitely a Republican. So we've seen a lot of Democrat and Republican opposition and a lot of Democrat and Republican support of a bill like this. So it's not clear that there's a left-right divide here at all.
The Stop Online Piracy Act is set for markup in the House Judiciary Committee on December 15th. Where are we with this law, and do you expect big changes to it?
Well, the Senate version, the Protect IP Act, has already passed committee, and it's waiting to be heard by the full Senate. It's stalled at the moment, but there's some speculation that the Senate might try to push through that bill in the next few weeks in order to avoid having to start over in the whole process again with the bill in committee. So we might see some action in the Senate. With the Stop Online Piracy Act in the House, I think if you had asked me a month ago, I would have told you that it probably would have sailed through committee and sailed through the full House with very little opposition, but things have really changed in the last month alone. We've seen a lot of opposition come out against this bill. From the tech industries, Google has come out really strongly against the bill. There's Yahoo and Google have either pulled out or threatened to pull out of the Chamber of Commerce for the Chamber's support of the bill. Facebook and Twitter have come out in vehement opposition to the bill, along with the traditional consumer advocates like the Electronic Frontier Foundation and Public Citizen and things like that. And now we're starting to see, individual congresspeople come out against the bill as well. So I expect in the Judiciary Committee hearings there to be a lot of effort to tie down some of these definitions, make them more substantive, and take away a lot of the looseness and open to interpretation aspects of the bill, and then we'll see where we are. It could be that opposition is great enough that the whole thing is scuttled, or it could be that something will come out of the Judiciary Committee hearing that, while not totally acceptable to the tech industry, isn't something they're so passionately opposed to, and then maybe we'll see it move through the House with little opposition.
That's Michael Dunn. You can find out more about the Stop Online Piracy Act and the Protect IP bill at BloombergLaw.com. You can find new IP podcasts each week at Bloomberg.com/podcasts. You can subscribe at both YouTube.com/Bloomberg Law and on iTunes. Thank you for listening.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.